Hello, Constitutional Law class. Welcome to Unit 5. Recall that the 1789 Constitution was ratified with a promise that a Bill of Rights would soon follow. As we've discussed, the first 10 amendments to the Constitution comprise that Bill of Rights. The 10th Amendment is perhaps one of the most enigmatic of these amendments. It states that the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. What can such a provision add to the delineation of federal powers already specified in the main text of the Constitution? If the commerce power is specified in Article 1, Section 8, and the court determines the boundaries of the commerce power, is there another external boundary on federal action in relation to the states in the 10th Amendment? If so, how would the extent of that boundary differ from the specific internal boundary of the Commerce Clause? In fact, for many years, the court understood the 10th Amendment merely as a kind of belt and suspenders to the structural Constitution. As the court said in U.S. v. Darby in 1941, the amendment states but a truism that all is retained which has not been surrendered. There's nothing in the history of its adoption to suggest that it was more than declaratory of the relationship between the national and state governments, as it had been established by the Constitution before the amendment, or that its purpose was other than to allay fears that the new national government might seek to exercise powers not granted, and that the states might not be able to exercise fully their reserved powers. In 1976, however, in National League of Cities v. Ussery, the court invoked the 10th Amendment to strike down a wage and hour law as applied to state and local government employees, even though Congress had authority under the Commerce Clause to enact national wage and hour laws. In a 5-4 opinion authored by Justice Rehnquist, the court held that the 10th Amendment imposes limits on such regulation beyond those in the Commerce Clause. Justice Rehnquist stated in his opinion that the regulation would impermissibly interfere with the integral functions of state government. After National League of Cities, lower courts tried with limited degrees of success to develop principles for when a regulation gets at integral functions of state government, as opposed to functions that were less than integral. In 1985, another Fair Labor Standards Act case reached the High Court, and a different majority of the court used the occasion to overrule National League of Cities. In that case, Garcia v. San Antonio Metropolitan Transit Authority, Justice Blackmun wrote the majority opinion. Notice that Justice Blackmun had written a concurrence in National League of Cities, which sought to confine that case to its facts. By the time Garcia reached the court, Justice Blackmun decided that the National League of Cities rule was unsound in principle and unworkable in practice. According to Justice Blackmun, the political process ensures that laws that unduly burden the states will not be promulgated. Garcia also was a 5-4 opinion. A dissent written by Justice Powell and joined by Justices Burger, Rehnquist, and O'Connor stated that the state's role in our system of government is a matter of constitutional law, not of legislative grace. In the rise and fall of National League of Cities' approach to the 10th Amendment, you can see a recurring theme in debates about federalism. Is the primary check on federal power in relation to the states fundamentally a constitutional matter or a political matter? If it is a constitutional matter, then the court can step in to invalidate Congress's legislative judgment about how federal and state authority over some issues should be allocated. If it is a constitutional matter, then the court can step in to invalidate Congress's legislative judgment about how federal and state authority over some issues should be allocated. If it is a political matter, then states that are dissatisfied with how federal and state power are allocated over an issue can let their voice be heard in Congress through members of the House and Senate who represent constituencies in those states. You can see how these different approaches will result in different power dynamics between the branches of the federal government, as well as different power dynamics among larger and smaller states and more diverse and homogeneous states with varying representation in Congress.